Breaking tonight, new questions about the future of the 2016 White House race following a week of bombshell headlines involving the most likely Democratic nominee. Welcome to the Kelly File, everyone. I'm Megyn Kelly. All week long, the White House and the State Department have been hammered with questions about how former Secretary of State Hillary Clinton seemingly flouted the law, using a personal email account to conduct all government business, leaving the American people to guess what she was doing on their behalf. Secretary Clinton doing no interviews. In fact, her only statement coming this week in the form of a 130-character tweet in which she called on the State Department to release her emails. You know, the ones that are sitting on her server in her home in Chappaqua, New York. Today, it emerged that the White House reportedly knew, at least as of August, that Secretary Clinton had transacted all of her electronic correspondence during her time as secretary on a Clinton-controlled account. And yet, the White House maintains this is not a White House issue. Meantime, Mrs. Clinton's allies attempt to downplay the matter, suggesting this story, broken by the New York Times, amounts to a political hit job. Earlier, I spoke with Charles Krauthammer, a syndicated columnist, Fox News contributor, and author of Things That Matter, which has sold more than 1 million copies. Charles, good to see you tonight. And so last night on the program, I had Lanny Davis, a Clinton defender, long time, and a lawyer as well. And I started to get a feel, and the audience did as well, for what the defense is going to be. And I'll give you the 3 points. Number one, the law changed. The law changed after she left office in 2013, and that's when it became really important that you not use personal email. And that's just not true. The law, when she was in office, required that any personal email that was used be maintained and not destroyed. And that was the law the entire time. And we still, to this moment, don't know whether all of her emails were maintained or destroyed.
Look, and also the regulations that she was living under, which came from the National Archives, were that all communication, all emails, had to be lodged with the archives. And of course, they are now lodged in her basement in a server that she owns. So, but this is sort of a classic Clintonian distraction. Was there a violation of the law? So we get into Clintonian distinctions. What is the meaning of is? And this is what they want us to talk about. What she did was wrong. Everybody knew it was wrong. The astonishing thing is, I think Lanny Davis at one point said, you know, there was no secrecy in this.
Everyone knew, he said.
Everyone knew. So there was no secrecy in her secrecy. But that's what makes it all the worse. It shows you their attitude. They knew you're not going to hide this forever. The emails are going out. They're on their own account. It's not the state.gov account. So they knew it would have to come out eventually. And they didn't care, because they are the Clintons. And the Clintons now for 20 years have operated in a place where there are rules, but they don't apply to them. They get in trouble, they parse words, and they've ended up always on the, you know, with the butter side up. And look, in her tweet that she said, you know, I'm asking state to release my emails. They are not her emails. By law, they belong to the federal government. And that law goes back to 1950.
And she's only talking about the 55,000. What about
exactly.
What about the ones that she culled through to get it down to 55,000 pages? How many pages are there? How many emails are there? We don't know.
And that's the essence. The reason for the law, which was instituted in 1950, is that the government has possession of them, and they subsequently be all kinds of laws which allow access. This is openness in a democracy. The Freedom of Information Act, anybody on the outside can ask for access. And you've got congressional inquiries, oversight. They have a right to inquire. And the key to the law, which goes back to 1950, is the federal government is in possession, so it decides if there's anything that has to be held back or redacted, but not the individual involved. The essence of the offense here is that she controls the emails, she owns a server, and that she decides, her people decide, we cull the emails, we throw out stuff or we hide stuff, who knows, that nobody will know about.
Which is a crime. That is a crime.
Well, I mean, whether it's a crime or not,
I'm telling you it is. You cannot destroy federal records. You can't do it. So if she had emails that she deleted that related to her state business, it's a crime.
Yeah, destruction is a crime, but I'm talking about the concealment and the ownership. And
also a crime. Concealment is also a crime.
Yeah, but look, we're not talking about if she gets a subpoena today and she now actively hides something. We're simply talking about the fact that she was keeping them for herself. We will learn if any were cold, thrown away, if a server was swapped out. But as of now, what we know today is she undermined the essence of the law, which is that some impartial observer decides what comes out and what doesn't. And that's why the story has legs.
But not only that, let me put this to you, Charles, because what's been happening over the past several years is Freedom of Information Act requests have been coming into the State Department. Lawsuits have been filed against the State Department. Subpoenas have gone to the State Department seeking information about Benghazi and otherwise. And you have an obligation to the State Department to respond to that person and say, we have looked through all of the records, including Secretary Clinton's records, and here are the responsive documents. They did that. And yet they either didn't call through Secretary Clinton's documents because they didn't look at her personal email, or they did and they just didn't produce a single relevant document. So what appears to have happened here is she successfully skirted her production obligations, and now State is saying they won't go back and look for responsive documents to any of those subpoenas or Freedom of Information Act requests. She's gotten away with it.
Well, not yet. And that's why the story has legs. I can imagine a very ornery judge who ruled on any of these Freedom of Information Act requests or oversight requests getting very upset when he or she learns that in adjudicating these requests for information, he was denied information from a State Department that was either ignorant or collaborating in this. I suspect it was ignorant. They didn't see anything from Secretary Clinton, so it reports we don't have anything. I can see a judge reopening this. Judicial Watch, which is the organization that went after a lot of this information and essentially got sort of, it was deceived. It's not going to sit for this denial of the reopening
but
of
let me
these
tell you
inquiries.
something about that, because we had Tom Fitton on last night. We had him on last night, and we actually had on Shannon Coffin, who's a former White House attorney. And the law, as evidence in an opinion that was issued just earlier this week, is very bad for someone like Judicial Watch trying to compel the production of documents that were only on a personal email account of a federal employee. I'm telling you, she may have successfully gamed this system.
Right.
But here's the other thing point I want to ask you about.
I just want to make one point. She's a candidate for the presidency. She may win legally on those challenges, but there will be a challenge. It will be a story. That's why it has legs.
That's exactly where I was going to go. Will this matter? Because you already see, some Democrats saying that this isn't a story. Jeb Bush did the same thing. There's no there, and yet it was the New York Times that broke this story. And so will the media stay on it, and will this impact the race?
They will stay on it because it is a Clinton. Because this is a revival of the sort of the modus operandi of the Clintons that everybody saw in the 90s and that people assumed would be ignored 15 years later because time has passed and the memories are sort of vague. No longer. What this scandal is doing and what the scandal of the millions that came in from outside the governments in the Clinton Foundation is doing is reviving the image of what the Clintons are and how they operate. She is running on the Clinton name and the memory of the good times in the 90s. That's her advantage in being a Clinton, peace and prosperity. But now what's happened is she has now revived the downside of the 90s, the downside of the Clinton years, which was the parsing of words, the skirting of the law, the operating outside of the rules that people might have let go of, but now is back in full force.
Charles, it's great to see you.
Pleasure.
Well, some political analysts now think they have figured out Hillary Clinton's plan for surviving this crisis, and you better believe it involves the media. Howie Kurtz is next to show us how it works. Plus, we're getting reports that the Justice Department could soon bring serious criminal charges against a top Democratic senator. See why he thinks this is part of a smear campaign against him. And after a DOJ report completely exonerates Officer Darren Wilson in the shooting death of Michael Brown out of Ferguson, Missouri. President Obama today appeared to suggest that Wilson merely got off thanks to a very tough legal standard. Did he read that report? Go to Facebook.com/The Kelly File to see what was said. Share your thoughts and stay tuned for the latest and a fiery debate.
We may never know exactly what happened, but Officer Wilson, like anybody else who is charged with a crime, benefits from due process and a reasonable doubt standard